Initially, I want to welcome everyone to what's probably the, I don't know, 17th, possibly a year that we're presenting these two-part HOA seminars, and we'll do 2 hours, approximately 2 hours tonight, and then approximately 2 hours on Thursday. So we've got part one, part two. This slide here is my firm's contact information. We have a number of resources on the internet. These videos included, going back many years. So if you miss something, or if you just have a few more hours to kill or are interested in more HOA training, that's on our YouTube page. So I'm not going to read this to you, but basically what we're doing tonight is discussing concepts. This is education. This isn't legal advice. I see on occasion, I saw it in court this past week, a pro se defendant had one of these slides and was wanting, I think, as best I can piece together his argument, to use it as some kind of evidence in support of something. You cannot use what we talk about tonight as legal advice. Legal advice only happens between an attorney and their client. Y'all are not my clients. I'm not your attorney. But if you do have general questions, feel free to put them in the chat. Anna's really good about bringing those to my attention, and we'll try to discuss these concepts. The purpose of this free training is to get board members more oriented, more equipped to promote, generate, foster community within their neighborhoods. It's not necessarily to give you legal advice. So these first few slides, and these are available online. You can go find these. That way I'm not going to spend much time on them, are the various resources that my firm provides that are available out there. So sometimes, and the internet is full of horror stories, and I mean, people say anything they want to on the internet. You can find various representations and claims about what the purpose of an association is. But in my world, generally, the association exists to promote community through information, education, and customer service. And it's not primarily a function of collecting assessments and enforcing covenants, although those are some of the administrative or governance things that associations do. But hopefully, as a board, either with your management company or self-management, or with the assistance of accountants and legal counsel, your board is spending the majority of its time not collecting dues, not enforcing covenants, but figuring out how to promote, foster, generate community, whatever that looks like for your neighborhood. Okay. Some of the other functions that associations do is manage extensive common areas or virtually no common areas. Some associations have swimming pools, clubhouses, green belts, lakes, ponds, walking trails, fitness centers, exercise courts, runways, represent a few aviation communities. But whatever the association owns, the board is tasked with managing those assets. And part of management, we'll talk about reserve funding a little bit later. Part of that management is making sure that maintenance isn't deferred and that adequate savings is done. And that's part of the leadership and governance portion as well. One of the questions that comes up sometimes is, why do we even have an association? And the reason, not only to do the things that I just went over, but the primary reason, if you're in Oklahoma County, Oklahoma City, Edmond, Cleveland County, Norman, even in some of what used to be considered rural counties, McLean and Newcastle, Mustang, the city requires a developer to create a homeowners association. Now, I'll get into language here in just a second. I'll go ahead and mention. So when I use the term homeowners association or HOA for short, I'm talking about in generality the community association for a real estate development. Primarily what we're talking about tonight is residential, but it could be a commercial community association as well. Sometimes I'm in a meeting, I was in one recently where I used the term HOA, and a couple of people went nuts claiming that they're a POA, that they'll never be part of an HOA. Okay, I guess there's something out there that someone has read that a POA and an HOA are two distinct things, and they're simply not. You can have a set of covenants that says Property Owners Association or POA, and you can have a set of covenants that says Homeowners Association, HOA, and they're the exact same thing. It's not the title, it's not what we call it, it's what the essence of the thing is. And we'll talk about this in a second. You can have a POA or an HOA that is a corporate entity or an unincorporated entity. It doesn't matter what the name of it is. It rests on the substance. This isn't a form over substance thing. It is a substance is the thing kind of thing. So don't get caught up if I use the term HOA instead of POA. Don't get caught up if I use the term dues and assessments interchangeably. It's just not the thing to get caught up on in this discussion. So what is it that makes this association have the rights and the responsibilities that it does? And I'll go ahead and mention, you can have a development, a plat and a set of covenants and not have a homeowners association. It is possible. It's just that for most developments, particularly ones developed in the last 10 or so years, in municipalities, they're going to have a homeowners association or roadway association or some kind of designated community association. Ideally, if you have an association, it's going to be incorporated, and we would know if it's incorporated by going to the Oklahoma Secretary of State's website, or I guess if you wanted to go to their office, you could. Most people just look at the website and run a search for what you think is the name of the association. So the way this typically works is if the name of your development, if the platted name is Happy Acres Edition, then you would go to the Secretary of State's website, go in their business services, and there's a search function that you enter Happy Acres and see what it pulls up. Of course, there could be a for-profit entity named Happy Acres, but a lot of times just kind of doing a little searching, we can find whether or not your association's incorporated or not. Now, what that Secretary of State's website is going to tell us is not only whether your association's incorporated, but it will also tell you who the registered agent is. Now, in Oklahoma, by law, every entity like a nonprofit, non-stock corporation, for-profit, stock corporation, limited liability company, those kinds of entities, they all have to have what's called a registered agent. And the registered agent can be the entity itself, but the components are you have to have the registered agent and it has to have a physical address. And for our homeowners associations, that's kind of a problem because we know the association itself can serve as a registered agent. That's not a problem. It's the address. You can't do a PO box. It has to be a physical address. And so then, well, are we going to use the president or the secretary who may serve on the board for a couple of years, but then they're going to move, or no longer want to serve, and they're still going to be getting the association's mail. So a lot of times our law firm will serve as registered agent. Sometimes managers serve as registered agent. But the main thing is whoever serves as registered agent for your association needs to understand what their obligation is. And the primary obligation of a registered agent is to get served with lawsuits. Now, where this is important, it's not because your association is getting sued right and left. It is because if there's going to be a foreclosure in the neighborhood, then the association is going to be named in that lawsuit. Now, I have heard that some managers, non-attorneys, giving legal advice to their management clients saying, well, we got served with this foreclosure petition, but you don't need to answer it. Just throw it in the trash because you're not going to see any money. That could be very, very bad legal advice. So you want to make sure your registered agent not only understands what happens when they're served, what kind of time frames, but also what kind of opportunity that is to have the association collect either on a lien or an outstanding debt. So that's the purpose of registered agent. That's one of the functions of being incorporated, in addition to some protections that we'll talk about in a minute. Now, bylaws of an association, they may be recorded, but maybe not. They certainly need to be adopted. I sometimes see bylaws that are unsigned. They look like a draft. Well, we need to have bylaws that have been duly adopted. Now, ideally, the way my developer clients want it, we will, right after the plat is filed, we will file a set of covenants, often called a declaration of covenants, conditions, and restrictions, and we will attach a copy of duly adopted bylaws to those covenants. They don't have to be, but we like to have it all in one package. If you find that your covenants for your neighborhood or for your association are not recorded, you don't have to run out and record them. There's no deficiency, but it is a good idea to make sure they're adopted on a website, available, and of course followed. Corporate resolutions, rules and regulations, these are documents that may be authorized under your covenants, authorized under your bylaws. Corporate resolutions are simply a document that function a lot like a meeting minute, but have a little bit more formality. Oftentimes we put it in a resolution because we want it to have some lasting effect, or it's something that we're going to have. We want it to be a standalone document. So, for example, the board in a meeting could discuss collections policy, and I move that this is what we do on our collections policy, second and voted, and that's going to be recorded in the minutes. That's perfectly fine. Or we may want to have a separate collections resolution so that it's not buried in meeting minutes somewhere. We've got this resolution book. It might even be indexed by topic or title or subject. And so it stands out a little bit more. All right, this slide is what a plat looks like. And plats, along with covenants, are filed at the county clerk's office. Okay. Now, a lot of the questions that come into our office, you might consider that they are down the line questions, so to speak, down the line in that we don't need to go back to the beginning and figure out where we're starting from. However, if the question is, does the association own any common area? Well, I wouldn't necessarily start with the assessor's office or the county clerk's office for deeds. I would look at the plat first, because the plat is going to tell us if there's even any common area to be owned. And so the starting place for a lot of questions, and the starting place for a lot of board members familiarizing themselves with the neighborhood and the functions of your association, really needs to be the plat. The plat's going to have not only the lots, the numbered lots and blocks, those are the parcels typically that a home or a dwelling would be constructed on. The plat's also going to identify the common areas. And on this plat, the common area is here right in the middle. And it's a it's a large this is a large pond or water feature in Lakes at Bridgewater up in Edmond. Plat's going to answer questions like, is the road private? What easements are available or in the addition? One of the questions that sometimes comes up is, can we access our property from a section line road and not the main entrance? Sometimes a plat will have something on it called a limit of no access, and it will help us answer that question. Plat's also going to have language, at least if it's in Oklahoma County, Tulsa County, some of the surrounding counties. It's going to have plat restrictions or plat notes, language that identifies that a mandatory association is in existence for the neighborhood. Sometimes it'll have language that the association's comprised of lot owners, something along those lines. So the plat it's an important document to have available at your disposal. And again, it is on file with the county clerk's office. A lot of county clerk's offices in Oklahoma, either because of their own production or because of third-party companies that have indexed and made copies of all the documents, almost the entire state, and I haven't checked recently, I don't know if all of the counties are represented by some of those third parties, but most of the time we can get copies of recorded documents. Sometimes we have to call county clerks to get copies of plats, because plats usually are larger documents, not 8.5 by 11. A lot of times they come in on, it's not actual vellum, but it's the glossy paper. So sometimes we can't get copies of plats, but you can get a number of them online. Tulsa County, Oklahoma County, those kinds of counties. So very quickly, the development process. Sometimes this is helpful to understand why we have certain things in our covenants, or why you inherit from the developer certain covenant language. And so overall, a developer's goal is to sell real estate. That's their commodity that they're selling. Now, sometimes that sales process is structured over just a few months, in that the developer files a plat, sells all the lots to builders, and they're done with it. Developer is out of it. Some developers have phased developments, meaning they will plat so many lots in phase 1, then phase 2 gets platted, and so on and so on. And it could be the phase development goes on for decades. I have a developer client that's over its 20th year in one development. And there's commercial aspects, there's gated community aspects, there's an overall association and sub-associations. So it could be a simple development or a very complicated one. And the developer is going to build into the covenants, or ideally the developer is going to build into the covenants certain protections. So this is where, when you see a Class B control period or Class A, Class B, sometimes Class C, if you see 3-to-1, 100-to-1 voting rights, if you see a section in the covenants that talks about reserved declarant rights, that's what's going on. The developer has thought about, okay, how do I want to maintain control until I sell all of my lots, and then I hand it over to the resident lot owners? That thought process usually is referred to as special declarant rights or reserved declarant rights, and it has to be expressed in the covenants. The developer doesn't get to sell all the lots and then get to make up the rules. The rules have to be recorded when the lots are sold or otherwise validly amended. And that is another one of the reserved developer rights that is often built into covenants, and that's the unilateral right to amend the covenants. But if that's not baked into the DNA or the written into the covenants, developer can't just make that up. But ultimately, at some point, the developer is going to be done with the development process, and then the next stage of that development will kick in. And that's transition from developer control to resident or occupant lot owner control. Now, if you were to go Google, when does my developer have to transition my HOA or the community association, more than likely what you're going to come up with from Google or whatever other search is 75%. That's not true. That's only true in Oklahoma if your covenants provide for 75%. The Google's telling you 75% because that is a thing in other states that have state law dealing with transition. We do not in Oklahoma. So the 75%, the 50%, it just doesn't exist in Oklahoma. So you would have to look at your covenants. You would either have to find language in the covenants that defines the transition process, or you would need to work out whatever that plan. Sometimes that plan is math. Some developers will do like a 3-to-1 voting or 100-to-1 voting or something like that. Some developers don't mess with that and simply say Class B control period is going to go for a very long period of time, or until we sell the last lot, or until we have decided we're not going to phase in anything else. One of the questions to look at in transition is the developer transitioning control of the association and design review, or one or the other? So it's often the case where the developer is ready and the lot owners are ready for there to be a transition of control of the association, but there's still construction going on, or there might even be an additional phase coming online, and the developer doesn't want to hand over design review board or architectural review committee. Sometimes people call it the ARC committee, architectural review committee. So sometimes the developer doesn't want to hand that over because the developer knows what kind of homes it wants in there, knows the original vision, and doesn't want to hand that off. So you shouldn't be surprised if those kinds of things are drafted into the covenants. That's very common, and it's kind of a no-brainer thing from the developer standpoint to put that into the covenants. Ultimately, though, if things go really well or even moderately well, the developer will sell all of their dirt, and both control of the association and design review will be in the hands of the lot owners. And then if there's covenants that the association, or excuse me, that the lot owners don't like, or that the association board just thinks is unmanageable, then it's also built into the process or into the covenants that they can be amended. And we'll talk about covenant amendments more in depth in part 2, which is on Thursday. But covenants are drafted by developers and their lawyers to suit developers, and not necessarily with 20 years down the line in mind. And so it is very common that after developer transitions out and has handed over control, that the covenants get tweaked with amendments to suit the neighbors. We'll, again, like I said, we'll talk about amendments more in a little bit. I talked about phased developments and pretty much covered everything on this slide. Let's talk about what the law is. I mentioned if you go Google when do we have to transition, you're going to find a state law called the Uniform Common Interest Ownership Act that is not applicable in Oklahoma. What is applicable, what is the law is, again, it's not my slides. It's not state law from Texas or Florida or California. They have their own statutes on how their associations are supposed to run. I give you the addresses of the primary law in Oklahoma, statutes at least, that apply. If you're a condo in Oklahoma, by the way, I don't think I said this. I think I just launched into talking about HOA and POA. Many of the concepts, the questions, the issues that are facing community associations in Oklahoma, they apply equally to condos and HOAs. Some of the issues with condos, like deferred maintenance, reserve funding, just the fact that it's a lot closer living and often shared wall, and then you've got that whole undivided interest in the common elements thing. Those are peculiarities for condos, but generally speaking, everything we're talking about is somewhat translatable between HOAs and condos. But in Oklahoma, you can search the statutes for the word condo or condominium, and you're not going to find it. What you're going to find is unit ownership estate. That is a very, very old definition or description of condo. Oklahoma adopted its Condo Act in the late 60s. It has never, and I repeat, never been updated or amended. That's mind-boggling. It's amazing. I have nothing else to say about that. So we have a 1960s version of the Condo Act, and well, in the words of a fairly prominent attorney at that time, wrote a law review article like in the early 70s and said it was woefully inadequate. And it remains woefully inadequate today. So that 60 OS 501 ETSEC just means keep on reading until you get to section 530, and then our Condo Act, more formally known as the Unit Ownership Estate Act, ends. So 501 to 530. Title 60, section 851 through 858 now is our Real Estate Development Act. This is a homespun set of statutes. 857 and 858 were added more recently, but 851 through 856 has been around, I think, originally in the early 70s, maybe mid 70s. And I think a couple of sections were tacked on in the 80s, but not a whole lot there either. Pretty bare bones, sparse governance, just kind of okay, this is a general framework, this is how you do it. But what it does do well is answers a number of questions that are important, and that's, can the association enforce the covenants? Yes, just like individual lot owners. Can the association recover prevailing party attorney's fees? Yes, section 856. Can the association file liens and foreclose on those liens? Yes, section 852. So and you can do the same actually in a condominium setting as well. So these statutes could be much, much better. I would say they're barely functional, but answer some of the more important questions that face associations. This Title 18, Section 865, 865, 866, 867, these are important statutes for homeowner association board members. And then that 1001 on into the 1900s in the Corporation Act. Those are various provisions that apply both to for-profit and nonprofit community entities, corporations. Associations are going to be typically nonprofit, non-stock. Now, that is not tax exempt. That is simply means you're not for profit and the association is not authorized to issue stock. It's not tax exempt from the IRS or U.S. Treasury standpoint. It just means you're not for profit. That's important because under that 865, there's a certain tax return that our associations will file on an annual basis. Residential community associations, it's not available for commercial associations. That provides really good protections under the law for the individual board members. And we'll talk more about that later. Title 16 is our conveyances. It includes title standards, things like 16 OS 16, which is our constructive notice statute. 16 OS 16 constructive notice is the what you commonly hear is ignorance of the law is no excuse. That's kind of the real estate version. So if you take title to property that is subject to covenants, including the ability to amend those covenants, well, then you're going to be bound by that. You don't get to say, well, I was okay with it then, I don't like it now, therefore I'm going to opt out. Or no one gave me a copy of the covenants when I closed, I didn't know about it, therefore I don't have to comply. That doesn't work because of constructive notice. If you want to look up various cases, if you want to look up these statutes, you can go to the address, which is oscn.net, Oklahoma State Courts Network. That's where you can look up all of your neighbors' divorces and traffic tickets and all of that, in addition to the actual law and not just the cases that are going on. Okay, I'm going to skip the next few slides. If you've got questions about home share, about chickens and quail in Oklahoma City and Edmond, if you want to talk about Norman's WQPZ and their statute, we can talk about that, but I'm going to move on. So earlier, I talked about doing a search of the Secretary of State's website to determine if your association's incorporated. And I make the assumption, maybe a safe one, maybe not, but it usually is true that most people on these videos or watching these videos are board members. So at least the ones doing the live training, maybe people going on the internet aren't. But one of the things that you should do, definitely as a board member and possibly as an individual lot or unit owner who's interested in your association, is prepare a governing documents file. And that could be a file folder, it could be something on your computer or iPad or tablet, but an organization of all of the applicable documents, because all of the questions, what do I have to do as a lot owner? Can I put up a basketball goal? As a board member, do I have to attend every single meeting? Do we have a mandatory association? Is it incorporated? I mean, all of those questions, they stem from the governing documents, and we have to have an organized file or folder in order to bounce those questions off of. So starting with copies of the plat, making sure our association is incorporated. And then in that process of filling out this folder or file, we will determine whether our association is incorporated. If it is not incorporated, I would strongly suggest that the board or the lot owners consider the importance, basically the pros and cons, what the importance of why so many associations incorporate. And there's very good reasons to be incorporated. Sometimes there's an irrational, or I would say uneducated, fear well, if we incorporate, then we're going to have to pay taxes, follow all these formalities. But I think what you'll find is if you do a pros and cons, most people will find that the pros of having a nonprofit, non-stock corporation greatly outweighs the detriments. So there's a couple of questions that came in. One of them, how can we do amendments grandfathering in existing rentals, but putting restrictions on new buyers, making the houses into rentals? We'll talk about amendments. That's whether you're talking about rentals, whether you're talking about backyard chickens or whatever. We'll talk about amendments in much more detail. And so file that question away and re-ask it if I don't cover. Will a copy of the presentation be available to us? Yes, it will all be online. Anna got that one. All right. So I think that covers all of the questions up to now. Some of the things that a corporation gets, one of the largest benefits that a corporation gets as opposed to an unincorporated association is the benefit of limited liability. So by design, your association, if it's a mandatory association, or I guess even a voluntary association that's collecting dues, you're taking money from different people, you're pooling it together and using it for a common purpose. Well, by virtue of pooling that money, apart from the fact that a bank won't allow an unincorporated association to open a bank account, it's going to have to be opened under some individual social security number. And I can guarantee you that social security is not going to be mine, not for an unincorporated association. So a lot of people will find that we create this corporate entity, we get an EIN, we do those basic corporate formalities so that we don't have this shared liability with this shared money that we're collecting. Let's talk about some basic meeting practice. And I'm sure you know this. You can go on the internet and see horror story after horror story and video of meetings gone bad. Unfortunately, we're seeing those with school board meetings, city councils, but I'm sure someone on here has either seen or experienced firsthand that kind of meeting in a homeowners association setting. It's unacceptable whether it's our HOA meeting, whether it's a school board, whether it's city council, for whatever reason, and we can speculate and I won't go into it, but we're seeing a difference, at least I'm seeing it in my practice in the last decade or so, just the way people speak to one another, the way accusations are thrown about, aspersions, whether it's online, in writing, to people's faces. It is barely functional. Oftentimes what I see is dysfunctional, and it gets in the way of promoting, generating community. It gets in the way of good communication. And it makes it very hard to listen to others when they're screaming at you. So these are just some things that I have found over the last 23 years of practice that seem to help either to keep in mind or to try to implement in our meetings. Now, this is whether it's board meetings or annual meetings. I will say one thing about board meetings is board meetings are for the business of the board. They're not to take the feedback, the insults or the yelling of individual members who show up to board meetings. It's often a great idea, just for transparency and customer service, to allow lot owners or members to come to board meetings. They need to see and hear the business of the association. That's fantastic. What's not fantastic is people yelling from their seats, asking questions, interrupting. I go to some board meetings, and that has been a practice for so long. It's become an entrenched tradition, and everyone has forgotten members don't get to participate in the deliberations and the discussions unless they're invited into it. And oftentimes boards will have a period of time when individuals can give their 2 cents. And a good model of this would be city council meetings, particularly if there's a contentious development. If there's apartments going up right next door to a development, guaranteed there's going to be people who are animated about it. But watch how mayors or whoever's chairing the meeting, watch how they conduct themselves and what they communicate. It's usually a kinder, gentler, more professional, courteous, as opposed to everyone being on edge, everyone being at each other's throats. There's just no need to conduct ourselves that way. And so you could practice, you could train by watching these good council meetings and then implement that. But remembering in our board meetings that you don't have to respond to yelling, you don't have to tolerate it. And at some point, if it becomes so distracting, you can simply ask those people to leave and ultimately have them removed if they're simply unable to contain themselves. So that's for board meetings. I will go ahead and say sometimes this pops up. People claim that the Open Meeting Act or the Open Records Act applies. I would encourage anyone who thinks, whether you're on the board or whether you're an individual member, anyone who thinks that the Open Meeting Act applies to your homeowners association, I encourage you to go read the Open Meeting Act, particularly the definition section, particularly the notice section of the meetings. And when you hit the notice, if you're not convinced that, okay, this has nothing to do with community associations, then maybe when you hit the part about inviting the governor to your meetings, maybe that will convince you this has nothing to do with associations. The Open Meeting Act, the Open Records Act do not apply to your association unless for some astounding reason your board or someone has adopted a bylaw or a covenant that requires compliance with the Open Meeting Act or Open Records Act. And the bad news there is you cannot comply as a private corporation with those acts because by definition, they don't apply. So don't know what you do with that if someone has improvidently adopted a bylaw or covenant that says they apply, other than just amend those. Ian comments about virtual meetings about muting unruly participants. That is a benefit that you get from Zoom. You know, we've been doing these education seminars ever since the pandemic hit, and you know, it's a trade-off. I like being in my home and not having to travel, being able to sit at my desk for 2 hours and do these, but I do really miss the in-person, the back and forth. I do kind of miss that. So, you know, one of the things that we have seen since the pandemic is not only having in-person board meetings, but offering a Zoom component. You know, boards, you got to find customer service wherever you can. And one of the easiest ways is, okay, we're offering a Zoom component so that people can at least listen and feel like they're getting access to the board's deliberative process. All right, so that I appreciate you mentioning that. Some of the things for annual meetings to consider, and this is, maybe it applies, maybe it doesn't. Maybe you tried it a few years ago and it fell flat on its face. Understood. The plight of the board and officers, it's just a nonstop plodding along and trying. And you need to understand, oftentimes it's going to be thankless. Most of the time, all you're going to get are complaints, but you're in the job. Look for those opportunities to get one to just a handful more people to show up to the annual meeting, because as you are aware, apathy in attending the meetings, it runs high in associations. So here's a couple of suggestions. Provide childcare, refreshments. It's okay to do door prizes, although guarantee someone's going to complain that the association has wasted its money or wrongfully spent money on door prizes. I'm sure you could find a local business person to donate those. That way you remove that aspersion. But thinking of ways of getting people to the annual meeting. And by the way, another good thing coming out of COVID, and this has actually been the law in Oklahoma for quite some time, you can do electronic proxies, you can do electronic notices, you can do electronic participation in meetings, you can do electronic voting. So if you just can't get the people there, if you just can't get the paper proxy back, an email will work, a text message will work for proxy purposes. If you're tired of spending an arm and a leg mailing out pieces of paper, if that's a couple $100 that your association would like to use and spend somewhere else, well, then go to electronic notices, and that may save you a few dollars. One of the last things that I'll mention is we like roadmaps. We used to use roadmaps. Now we use apps, but each one of them, they give us a dot-to-dot or a how-to. Well, there's the exact same thing for meetings, whether it's annual meeting, whether it's board meetings, workshops, whatever, and that's called an agenda. The agenda is simply our meeting map or navigation document. This is very helpful to keep us on track, and it also helps keeping us from spending hours and hours and hours in meetings. If you're having 4-hour board meetings and it's not about emergency or a crucial funding crisis or upcoming big annual meeting or something like that, well, then we need to consider we're spending a lot of time, wasteful time. Sometimes meetings get bogged down because the secretary is trying to write everything down. We'll talk about meeting minutes, I believe, next. And we might be having long meetings because our secretary thinks meeting minutes are a transcript. They're not. They are simply a record of what happened at the meeting. What was the date? Who was present, so that we know 5 years from now that there was a quorum? Who made a motion? Who seconded it? And was it approved? And what was that motion? You don't need the debate going back and forth. And sometimes I'll find even meeting minutes of executive sessions. And we don't want meeting minutes for executive sessions. The purpose of executive session is for the board to have full, frank conversation. So for example, you're thinking about firing an employee. Well, you don't want to have that conversation in a regular session, in a regular meeting. You go into executive session and a board member can feel comfortable saying, look, I know this person is well-liked, but I have a concern about their performance, and the board can come up with whatever the plan of action is. Fire them, counsel them, whatever, no action, and they can hash all of that out in executive session. Then they come out into regular session, and I move that we fire so-and-so, or I move that we caution or counsel or whatever the action is, or non-action, second, vote, and that's what it is. We don't need all of those gory details in the regular meeting minutes. All right. And then I talked about what resolutions are. The primary importance from my standpoint, apart from just being able to go back and piece together what happened, but when we're in court, when we're litigating in a corporate setting, homeowner association, condo association setting, the meeting minutes are prima facie evidence of something. That something could be that a meeting even occurred, that there was a quorum of board members, that a certain act was authorized or approved or voted on by the board. Now, the term prima facie means on its face. So it doesn't mean that our meeting minutes are bulletproof, but what it does is it creates a presumption of validity that if someone wants to say, no, that's not what happened, well, then it shifts the burden to them to prove it, which is helpful because, as I'm sure you know, you get people popping off in email or meetings, making crazy statements, defamatory statements, unhelpful statements, and people are going to say what they're going to say. But what we're not going to do is have these ongoing gun battles about whether the board has made a proper decision, a defensible position or decision when we have meeting minutes. So those are very good tools, not just to keep track of who said what or who moved what and whether it was approved, but also if someone wants to undercut a board decision or position, we need to have meeting minutes to support that we had a meeting, there was a quorum of the board, they made a motion, they seconded it, and then it was approved. Now, it is entirely possible that your meeting minutes are not as formal as that. And that's perfectly fine, although maybe one of the things you learn here is better meeting minutes require less evidence if it comes time to prove them. But, some semblance of meeting minutes written on notebook paper is just as useful as something that's typed out, provided we can read it. All right, so that's enough on meeting minutes. All right, we're about halfway through. One of the benefits of having a corporate community association is that if we don't have a set of bylaws, the Oklahoma statutes will supply some very important definitions and default provisions. This UOP, unless otherwise provided, you'll find this in statutes that says, okay, unless otherwise provided, meaning unless you have a set of bylaws, unless you have articles of incorporation that specify a quorum, if you're incorporated, then we will supply a quorum provision for you. So if you have an incorporated association, the articles are silent on quorum, you don't have a set of bylaws, well, then we know the answer to, well, how many people do we have to have in a room, either in person or by proxy, in order to conduct business? That's what a quorum is. Well, the law says the default is 1/3. Well, for your association, 1/3 might as well be 100%. It's maybe impossible to get even a third. So in that case, maybe we want articles of incorporation or typically bylaws. When we find extensive articles of incorporation with lots of provisions on the functions of the association, the notice, officer board positions, all of that stuff, quorum, my guess is that we're dealing with a fairly old set of articles. More modern trend is to have very bare bones articles and put all of that language in your bylaws, but they can be in either one. Most of the time, though, our quorum provision is going to be in bylaws. Now, I guess you could put this under the category of pro tip. You may want to check your covenants if the meeting's purpose is to increase dues. There are quite a few sets of covenants that contain a quorum provision, a very special quorum provision just for dues increases. And so you may have this secret hidden little or it's just hiding silently quorum provision in your covenants, when most of the time what we're looking for is a quorum provision in our bylaws. But it can be 1/10. There are different ways of reaching quorum. One way is you send out notice, and the bylaws say if you send out notice and there isn't a quorum present, then the persons can adjourn, announce a new meeting, and at the next meeting, a quorum will be whoever shows up. That's called a deemed quorum. And there's different ways of doing that. Sometimes bylaws require you to send out notice again and again and again and still get whatever the quorum is. And some associations are locked in jail, it seems like, to conduct business. If that's the case, then oftentimes an attorney can look at that and help you figure out a strategy of how to get out of that. Question: what are your thoughts of utilizing a policy and procedure document outside the covenants or bylaws? I like policies and procedures as long as we're not getting into a danger zone of trying to go around or behind covenants or bylaws. So I'll give you a real plain example. If you have covenants that are, for whatever reason, impossible, very difficult, improbable to amend, and there's language in there that says something like, no basketball goals allowed, black and white, no discretion, there's just no basketball goals. Well, sometimes the idea comes up, okay, well, we can't amend the covenants, but what we'll do is we'll adopt a rule that allows for basketball goals, provided they're temporary and you put them up. So now what we have is clear covenant language that is unambiguous. It doesn't say no permanent basketball goals and temporary ones are allowed. It's a all or nothing. We can't go around that with a policy or a procedure or a rule. More often than not, rules deal with things that the covenants or the bylaws give broad discretion over. So, for example, if the covenants create a architectural review committee and that says the architectural review committee shall adopt policies and procedures for its operation. Well, now we have express authorization under the covenants for adopting policies and procedures. Sometimes the covenants won't be that clear. It'll say the association board shall administer and oversee the common areas. And the common area happens to be a green belt and a swimming pool. Well, we need policies and procedures on how the pool is going to be open, who can use the pool when, whether I can swim and cut off blue jeans with my dog Roscoe in the pool. True story, not me. A condo association had that issue. So adopting rules and regulations for governing common areas, fitness areas. This was a big deal during COVID, where we had this strange new social operation or social interaction requirements coming down from the government, and it seemed like this moving target. And we had a lot of associations adopting COVID policies, particularly fitness areas, social distancing, all of that. So that's typically how we will use policies, procedures, rules, and regulations. Now, I will also tell you, and my covenants are this way. So the covenants that I draft for developers that lot owners inherit, they have very extensive rules provisions that read almost like covenants. But the thing is, they're of record. They're filed in my covenants. They're Exhibit C, and they're titled Rules and Regulations. So those are filed of record. They have the notice that a covenant has, but then we also build in some flexibility that the board or the lot owners can modify these rules and regulations without actually having to amend the covenants. So you might find some hybrids, well, these look like covenants, these are filed like covenants, but they're called rules and they operate like rules. I like that system because we get the best of all worlds. We get the constructive notice that we get with covenants that are filed, but we also get the flexibility of rules. All right. I covered quorum. One thing that I didn't mention was, and hopefully we never have to go there, or you never have to go there, but if the wheels fall off when it comes to corporate business, then the courts are open. If you look at Title 18, Section 1060, if there's a couple other sections dealing with contested elections, the local district court has what the statute calls summary authority. It can summarily adjudicate, which means you don't have to have a jury trial. You don't have to go through a full trial. The judge can have an evidentiary hearing and then make a ruling on corporate elections. So if the lot owners simply cannot agree to the very basic of having a fair election, if we can't even agree on the process, which is mind-boggling as Americans, that a group of 100 people who cares if we like or can't stand each other, at the very least what we could do is agree on what a full and fair election looks like. But if we can't, if unfortunately we find ourselves in that situation, we can pay lawyers to take us into court and we will get an election ruling from the judge. So that is always available if we're not unable to resolve it ourselves, but most of the time we can. One of the things that pops up that I would say we've come the closest to having to get a judge involved is when you have an individual who makes claims that simply aren't supported either by the bylaws, the articles, or by Oklahoma corporate law. And one of the areas that this pops up is with proxies. So generally speaking, if you have a board or if you are a board member, I guess this is repentance time. If conceptually you think proxies are a thing to limit voting, if you think quorum is something to wield as a sword as opposed to a shield, if we think of corporate procedure as a weapon, we're thinking about it wrong. The idea of a quorum is minimum safety net. The idea of proxies is the more the better. And in fact, proxies are how we often will get quorum. Proxies do not have to be notarized. And that is something that as soon as I hear a board member or an officer or manager, lawyer, anybody say, well, we won't accept this proxy because it's not notarized, immediately I'm thinking, okay, this person doesn't understand, number one, the law on proxies, or they're trying to use proxies as a weapon. Proxies can be a text message, they can be an email, they could be a fax machine, they could not be a smoke signal because that's not electronic, but virtually everything else is fine. Oral proxies are not fine. They can be in any kind of writing. You can scribble it on a cocktail napkin. You could send an email, text message. I'm pausing because I haven't had to address this, but I assume a social media post, a TikTok message, invariably someone is going to try to use that as a proxy. I suppose that could be considered an electronic communication. Personally, I don't like it. I don't have anything against TikTok, but how hard is it to send a text message or an email or get a faxed or a scanned piece of paper over to your association? I just think for record keeping purposes, for formality's sake, we should probably stay away from social media posts, but I don't have a problem with text messages. If the association has the ability to receive that, if the secretary's fine receiving text on their phone, then the law supports it. So, and I give you the site. If you want to read this for yourself, it's in Title 18, Section 1057, and then you're going to look at subsections C and D. This 18 OS 1060, this is the bulk of corporate law for our incorporated community associations. There is a lot packed into 1060. So 1060, and then also 1065, which we'll talk about records here in just a little bit. The question often comes up is, how long are proxies valid? Unless otherwise provided, either in bylaws or in the proxy itself, the proxy is valid for 3 years. Now, a really good corporate practice to get people to participate and for the association to get its quorum is to use a directed proxy or a voting proxy. So the way this works is a proxy at its base is something that says, I, Matt, give Anna my proxy for purposes of quorum and voting purposes, and that could be it, period. Well, I mean, that is a blank check, and without more, it's only going to be valid for 3 years. It's going to be valid for every single meeting, every single opportunity. Anna wants to show up and use my proxy, she can, because that's the way I drafted it. I could limit it and say, I want this proxy to be only available for quorum purposes for the next meeting, or only for meetings within the next 3 months. That's a limited proxy. It's only valid for quorum purposes. So Anna couldn't show up and use my proxy for voting. All right. I could, if I know board members are up for election, if I know their names, if there are certain measures that are going to be voted on, then we could draft a ballot and a proxy. And now I don't have to go to the meeting. It's almost like absentee voting. Those are very, very handy documents, but we have to make sure that they're drafted properly and that they serve the function that we want them to. Okay. Dealing with electronic communications, this was the slide I think that an individual was wanting to use in court the other day. The newspaper rule doesn't mean that the emails of board members are automatically evidence in a case and automatically discoverable. They could be, they might be. There are a whole host of issues to address to determine whether those emails are going to come into evidence. The primary one is, are the emails even in existence? So boards may have all kinds of ways of communicating with one another. You may text one another. There may be one Google email address that splits to personal accounts. However it's set up, you just need to bear in mind that it's possible that those communications, just like the meeting minutes, just like letters that the board sends to individuals, all of that stuff could be in evidence. And so if you want to name call someone and you want to be foolish enough to do it in electronic communications or in writing, you just need to be able to withstand the scrutiny and the critique if that communication comes to light. The better course is to have official channels of communication, very clear record keeping rules. And I understand your volunteers that the board transitions in and out, people move, people lose their phones. And so record keeping for associations is a challenge. Sometimes we have gaps in meeting minutes. Sometimes we have gaps in emails. And that's as long as that's not intentional once litigation's filed, well, then that is what it is. I already talked about electronic voting, and I would encourage you to avail yourself of that if you can. I talked about Open Meetings Act, mentioned Class A, Class B. One of the questions that comes up, and boards should avail themselves of this if they can, board, you do not have to be in the room together to meet, and you don't have to be on a Zoom call to conduct business. So there's something called a consent in lieu of meeting. And if you look at your bylaws, it probably mentions this. So there are any number of decisions that the board should make, that they don't need to be in a room together. You don't need to wait 30 days. What a consent in lieu of meeting is basically if the entire board agrees, if it's unanimous, then circulating an email or being on a group chat, that will suffice, but it has to be unanimous. If there is one dissenter, well, then that's the trigger for it to go to a Zoom meeting or to an in-person or telephone meeting. And that makes sense. If we're all in agreement, then there's no reason to delay. We can circulate an email, all in favor, yes, yes, yes. All right, fine. We've all authorized the president to spend $50 for Christmas decorations. We don't need to schedule a meeting for that. But if one person says, wait a second, I want to talk about this, I have some reservations or I have some questions, and if those reservations or questions can't get resolved in whatever the communication format is that you're using, well, then you need to have a meeting. That's how boards work. One person doesn't get a veto, but they certainly do get access to the full and fair process. Just like our elections, it has to happen for board meetings. And what that does is, it's not just the 12 angry men effect where, well, that one person could be right and end up converting all of the board's minds on a particular topic. But we at least have to allow for that minority voice to have their full and frank say. They may get outvoted every time, but we have to give them that opportunity. Now, if that one individual is throwing a tantrum or pouting or intentionally trying to make things difficult by objecting to every consent vote, well, that's something else that's going on, and we would need to address that possibly in an executive session. But okay, what is it that is driving this behavior or this idea? That's an opportunity for the board to come together, to hash that out. It's not the right word, but basically have a listening session and find out, okay, why is it that you feel we need to slow the process way down, or you're feeling disgruntled or whatever. The board needs to not necessarily agree. You're not going to agree. That's not what consensus is. Consensus is, I'm operating in an environment where I might get outvoted, or I might vote with the majority knowing that I don't necessarily agree with it, but it's been a full, frank, fair process, and I feel supported, I feel listened to, and I feel comfortable possibly voting against what I think are my own interests. We do this in relationships all the time. And that kind of board, that kind of operation on a board is a very special thing. It's a thing to be promoted, fostered, and I'm hopeful in some little way these videos and these trainings help to create that kind of environment, because that really is a fundamental thing, not just for making good board decisions, but also helping lot owners regain their minds when they lose them in meetings and start mimicking some of the things that we see and hear on television or on Facebook. I mean, if the board, the way it operates among itself, can somehow radiate that to your lot owners or your unit owners, you're doing very special, beneficial work, and that is the fundamental heart of community association. So use your board meetings as practice, help one another, speak to one another the way that fosters that kind of environment, model that to the members, and hopefully from a grassroots effort, from our neighborhoods, the lowest level apart from the family of governance that we have, hopefully that will radiate up into local government, state government, federal government, and we can have a better communication. All right, let me catch up with, speaking of communication, what do we do when communication fails? This is, I won't say this is why most people come to these videos, but enforcement's a big deal. Enforcement ultimately is something that parties choose, whether they choose that this is the hill that I'm going to die on, or we're not going to be able to negotiate a resolution. I certainly understand that there's people out there, and they put it in writing, that attorneys like conflict and will churn cases and just keep them going. I assure you that is a rare thing. Most attorneys are going to try to get their clients to understand how cost-effective and time-effective resolution is. But ultimately, just like speeding limits, just like traffic laws, just like the Internal Revenue Code, if people decide, look, I don't care what the paper says, I don't care what the board says, I'm going to do what I want to do, and you're going to have to stop me. The covenants have teeth. That's something that I hear. Well, what teeth do the covenants have? Most covenants have the sharpest, longest teeth available to do what you need them to do, and that's obtain an injunction, prevailing party attorney's fees, all of that. Now, just because the association or individual lot owners, for that matter, can enforce the covenants doesn't necessarily mean that they should, or that they even want to. Litigation, if you're haven't been involved in it, is very expensive and time consuming, and there is no guarantee that you're going to get your money back. So usually what we start with is this guy with a fantastic haircut and what looks like extending his American single finger salute. But the illustration here is important. And so when we see things from a different angle, sometimes the initial thought, our initial reaction isn't exactly what we thought it was. So he's given the British 3 instead of the American 1 in this photo. And this is just a funny illustration of, okay, the very first step, once we think that, okay, this person is thumbing their nose, or this person isn't doing what we think they should do, now it's time to call the lawyer. That's not when enforcement starts. Really, for my associations that I represent, the idea of enforcement needs to be something much broader and nuanced, if that's the right word, than, okay, call the lawyer, it's time to pin this person's ears back. Enforcement, which I guess we could define enforcement as getting people to do what we think they should do. Not necessarily what in objective reality we must do, because that is be born if we're going to be in existence and then ultimately die. That is objectively what we must do. So in terms of enforcement, getting people to do what the covenants plainly require them to do, or what we think they should do, it starts at closing, maybe even before closing. So again, going back to the idea that as a board, we're looking for opportunities to provide customer service. We're looking for opportunities to speak that calm reasonableness into people's lives, to communicate our community is home, and this is what that looks like. This is what that sounds like. This is what that feels like. However that's defined for your neighborhood. That is often communicated first, either well, poorly, or not at all, at closing. So we have these welcome home committees, call them welcome home committees. We have the very, very common process of the closing letter. If your association uses a management company, it's probably built into the management agreement that they're going to provide these closing letters. And that's simply a title company who's handling a closing, which is the vast majority of closings of real estate in Oklahoma, is going to ask the association for a closing letter. And the manager has this form letter that says, yes, dues are owed, or no, dues are not owed, dues are X number of dollars. Well, we can greatly expand that and include language of, we're so happy that you're our new neighbor. We welcome you to the neighborhood. Here's a small gift. Here's the information that we think is important for you to know. We're a covenant restricted community. This is where you send your dues. This is how you pay them. We have online portal. Here's the top 10 things that might surprise you about our neighborhood. Number one, we don't fight with one another, and we don't tolerate online temper tantrums on our Facebook page, however you want to phrase that. But your messaging, we are calm, we're professional, we don't go for each other's throats, because at the end of the day, we are still literally going to be neighbors. Okay, you can turn your TV off, but you can't move your house, or turn your computer or your phone off, but you can't move your house. We will still be neighbors. So communicating something like along those lines. Number two of the top 10 things that might surprise you about this house, we have a covenant that says you can't park in the street. So what you're doing is you're layering in this communication things that you want this person to understand right up front, that we have an expectation based on covenant language that we don't park in the street. And you include those, call them negatives. Some people think no street parking is a great positive. Otherwise, they wouldn't put them in covenants. But you layer them in. It's not a 10 commandments. It's not a thou shalt not. It's not do this or else. Here's all the penalties that could happen. It's not that kind of communication. It is a gentle, warm welcome, and here's some important things that you need to know. It's almost like, you know, a friend coming alongside you and giving you the inside information of how to navigate this thing successfully. Here's the cheat codes for the covenants, so to speak. I guess if you're a gamer, I'm not. I just know that there's cheat codes out there. And also what you're doing is you're communicating what the expectations are. Many people, if they just know what the rules are, if they just know what the expectation is, they will try to hit it, or at least try to avoid not hitting it, because they don't want the nasty gram or whatever. And then lastly, on this slide, I know this sounds stupid to a lot of people, but it is amazing and it is incredibly powerful how well associations can operate, how little attorney's fees they can pay if people will ask the question, what if enforcement looked more like educating and serving? I'll give you a great example. Trash cans, leaving trash cans out, people about can go to war over it. And this trash can, particularly between neighbors, can become this proxy for all of the political, religious, socioeconomic strife in the world. It's just, the focal point is this trash can. And so they start projecting all of these things on their neighbor, and now they're Satan incarnate living next door, leaving their trash can out. Imagine what happens to that relationship and that thinking if, when you see your neighbor's trash can out, instead of that being the springboard for everything that's bad and wrong about the neighbor, how about your hand drags that trash can back up? Now, this is where people are like, give me a break. No, I understand. I get it. But you can't imagine how powerful that is, not just to your neighbor, but also to your thinking. So that is just a little what if. That's not to say I think everyone should get away with murder and we should condone bad behavior. That's not what that bullet is communicating. Hopefully that's not how you take it. All right. If you weren't scared before, this is my attempt to scare your pants off. Not really, but you need to know about this, particularly as a board, as a homeowner, as a landlord. There is something out there called hostile environment harassment, and it applies to your HOA. I won't go into the details because the middle bullet here says totality of circumstances, and that simply means you can read through this. My goal is to make you aware that there is something out there that is called hostile environment harassment, but there's no way we can diagnose or forecast every single case. The crux of this is, and this goes over a couple of slides, if there is a condition going on, so for example, you have a landlord who is of one race, one ethnicity, one gender, one religious bent, one country of origin. I mean, pick your protected class, different from their tenant, and they are clearly using that difference as a means to unfairly discriminate against that individual. The fact that it's a landlord tenant, the fact that it's a lot owner versus a lot owner, where the board traditionally has the ability to say, look, this appears to be a private matter between landlord tenant or lot owner neighbor to neighbor. The classic there is neighbor complains to the board that their neighbor's dog is driving them crazy. Routinely, the response to that is, we hear you. It would drive us crazy too, but the board's not going to get involved. That is still okay. But if there's any indication that there's some kind of discriminatory intent or practice going on, the board can't simply say, not our problem. So at the very least, the board needs to have a conversation, some kind of policy. Someone asked about policies. This will never be spelled out in covenants or bylaws, but it definitely needs to be spelled out in a policy. What is the board's intake procedure? How is the board going to navigate the investigation? What kind of resources? Is it going to outsource it? It has to have some kind of plan in place of is this going on? And then based on the totality of circumstances, decide what it's going to do. And the standard is the association has to be proactive. It can't simply take a hands-off approach. And this is difficult, and why the board needs to think about it ahead of time and have a plan in place, think about the standards, what are the hallmarks that will tell the board, okay, this isn't just two people being ugly to one another or two people being unreasonable, or this is more of the political stuff or the religious stuff that we see on social media. This is something different that we need to be involved in because it's possibly hostile environment harassment. And I give you two examples. So there is a case where there was a male HOA president, somehow got crosswise with a lot owner, used frequently. This wasn't a one-off, it was a frequent use of terms that traditionally have been only derogatorily used against women. And that was a circumstance where the association needed to take action because it was clearly a gender-based discrimination situation. Other situations that pop up that we need to take a closer look. So in condominiums, it's much closer living. Sometimes smoke smells, candle smells, cooking smells will travel through walls, through duct systems. Well, if an individual complains to the board that they're getting a strong cooking smell coming through the vents, that may or may not be anything. Or it could be a proxy complaint and attempted prohibited discriminatory housing situation because of a person's country of origin, or religion. It's a situation that boards need to be aware of, and that the right response is never not our problem. Okay, so it's not a sky is falling deal, but it is definitely something that is out there that boards need to be aware of. So in addition to the thought process of, okay, how are we going to help educate our lot owners from day one or pre-day one before they're even HOA members? How are we going to try to resolve conflicts when things do pop up? So we can't set the standard, or we can't operate under the idea that a well-run association, or if things are right, then people won't disagree. That doesn't work in families, it doesn't work in churches, it doesn't work in corporations, it won't work in your association. If your idea is, well, things are only going well if everyone's in agreement, you are going to be perpetually tied up in knots. It's not whether there's conflict. There is always going to be conflict. The goal is, have we created an environment where we have the tools and the people trained with those tools necessary to resolve conflict? There isn't a person alive who doesn't lose their mind at some point When I use that term, I'm talking about, I get so fixated on the road that that's my parking space, that I'm going to speed up and not let you in. There's nothing wrong with that. I'm probably well within my rights, particularly if it's a car coming in. But why do I need to do that? And so this isn't about bending over backwards, being deferential, splitting the baby. We have all of these concepts and phrases that we use about compromise, but that's not what we're talking about. What we're talking about is having clear lines of communication, having at least the basic relationship where I don't think you're out to get me. And until I'm fully convinced that you are out to get me, I'm not going to engage in conspiracy theories, and I'm not going to treat you like an enemy who needs to be destroyed. I'm going to leave room for the possibility. I'm going to ask myself, now, wait a second. I thought Jane was a reasonable person. I thought we shared a lot of the same views, particularly how to deal with association debt. I'm hearing something very different. It needs to spark a space for, did I get this wrong? Did I misunderstand her? Jane, can you repeat that? Because I'm hearing something different than what I would have expected. And so I want to hear where you're coming from and why. It needs to have a space for honest disagreement. Now, we have a safety net in these board meetings, in these annual meetings, and that's voting. We're all familiar with the voting process. There's a majority, there's a minority, there's a winner, there's a loser. I can convince people with my eloquence, or possibly with my money, whatever it is I have to share that might win people over, and I can get the votes, and I get my way. That ultimately is how it goes. What we are trying to avoid is situations, methods of communications, reactions that are damaging to our basic functions of community association life. Having such bitter disagreement that my kids are no longer allowed to play over at your house because I'm so mad at you. I mean, in reality, there are only a few reasons why that should happen, and primarily it's because there's criminal activity going on at your house, and I don't want to expose my kids to it, right? The fact that you and I don't vote for the same president should not be a reason why our children can't interact with one another, why you and I couldn't have a beer together and sit in each other's living room and talk about, I don't know, upcoming elections. But for whatever reason, and this is where I think our associations could be instrumental in pushing back, is the idea that, well, if we're not on the same page 100%, well, we're just polar opposites. There's no room for discussion. There's no reason to discuss it. One of the things that we can do as board members is structuring discussion to remove conflict. Well, what does this look like along with structuring procedures to remove conflict? One way is to get buy-in. And this isn't some tricky, slick marketing thing. It's basically transparency and communication, and it's help to the board in making decisions. So where this comes in a lot of times is with covenant amendments. Very rarely will a covenant amendment project be an individual in the neighborhood leading the charge. It's almost always the board who comes to me or has this, we feel like we need to amend the covenants. So the board could certainly run with that idea. The board certainly has the purse strings and can hire the lawyer and pay for the work and then send it out for a vote. But guess what happens when they send this proposed covenant amendment out to a vote? A lot of people will receive it and think, well, where did this come from? I didn't have any notice that this was even a topic of discussion. So we could structure the discussion to remove conflict, certainly not eliminate the possibility of all conflict, but we can certainly help ourselves, and we can forecast, and it's reasonably foreseeable under certain circumstances that conflict could arise. And surprising things, special assessments, dues increases. It's common in covenants that boards can increase dues up to 20% per year without a vote of the membership. But I can assure you that that's going to create a little rub if all of a sudden covenants go up 20%. If that's a necessity, if the board has determined, look, we just can't make it. And the reason is because the prior 10 boards thought it was a bragging right to keep dues abnormally low. And they just deferred maintenance. They, ran on a shoestring budget, and now it's catching up with the present. Well, the board needs to communicate that. If the board wants more money just because it wants more money, well, then be honest and say so. We want more money because we want our dues to match the other high-end neighborhoods around, and we want to spend like those neighborhoods. Well, if that's it, then communicate it and state your case, argue it, and see if you can get enough people to agree with you. So that's what I'm talking about in terms of structuring discussions and procedures to remove conflict. It has to do with communication and how we communicate. Another thing that may sound silly, I won't spend a lot of time on, there's plenty of good resources out there, and that's how to get ready for difficult conversations. If you know you're going to have a difficult meeting, if you know you need to go talk to your neighbor about their barking dog, your hands get sweaty, your stomach gets upset, your body does those things that I assume everybody, most people's bodies do, unless perhaps you're a sociopath and have no emotion. But most people get nervous. It's your body telling you that, hey, brain is thinking about something important, or at least important enough that they want to get it right, or they want to win, or they want to not look stupid, whatever it is, and the body's getting all wiggly and nervous and sweaty because of it. Practice. You can actually minimize or use those body reactions that feel like you're dying or freaking out or doing something wrong. You can actually use those to your benefit, or at least help practice get the words right. All right. We've got a few minutes left, 12 minutes. If you have done all of this, if you have gone to your neighbor, or if you've gone to the board, or whoever it is, the group or the individual is that you want to have the conversation with, and it doesn't work, well, then the very next step, typically in conflict resolution, is you go make another attempt, and you take someone that you think that individual or that group will listen to. Not necessarily your lawyer, not necessarily someone carrying a bat or that's threatening. That's not the idea. The idea here isn't we're going to browbeat or threaten this person into submission. The very best conflict resolution is when you get the other party to agree with you that they need to do, or whatever needs to happen is going to happen. That's great, because sometimes you'll actually end up in a stronger relationship with the other person, or you may get a really good board member out of it. Somebody wants to participate that was like, I can see how important this is now, and now I want to work on it. Or, as is most often the case, they may disagree with you, but What they can't do is challenge your approach and your sincerity, your lack of rough handling. And we get this as lawyers. Very few opposing parties like the association's lawyer. I get it. And I really couldn't care less what people say in writing or to my face. But what I need to know, what I have to make sure, is that the individual's been treated fairly and according to the process that's set out in the covenants. That may be your only consolation as a board member. And so do that part well. If that's the only thing that you can guarantee, that you have treated this person with the same respect that you would want if you were in their position, that they got every due process that was available to them, that is leading the horse to water, right? That's sometimes as good as it gets. You know the adage, you certainly cannot make them drink any more than you can make someone comply with the covenants. All right, so there's other ways of more formal conflict resolution, mediation, binding arbitration. You may just need to look at your covenants and see if it requires that. Let's talk a little bit about records. Well, there's one. Let's see. Question about the hostile environment harassment slide. Yeah, that it seems like you're involving yourself in private matters. The way this comes up is someone has complained to the board. So one of the parties, almost always, if not always, the person who is being discriminated against or treated unfairly, wrongfully, harshly, they come to the board and ask for the board's help to do something. That's the trigger. It's not there's a landlord tenant and the rumor mill is that the landlord's treating the tenant poorly and now the association has to jump into action. That's not how that works. There has to be some kind of trigger. Now, the trigger could be, and again, this gets into the totality of circumstances. The trigger could be that there's an anonymous complaint that keeps coming into the association's hotline or whatever, and it just happens to be against this one individual. And we have a really good idea that this anonymous complaint keeps coming from the same individual, and we have some other facts to indicate that it is based on a discriminatory motive. So it doesn't happen in a vacuum. There's something that involves the association or some request on the board. And I agree with you. There are circumstances that can seem, why would this be the association's responsibility? Why should the association be involved? It's because federal law requires it. It's just like you have associations who in good faith want to have a quiet adults only swim time, and so they have adults only day. Well, why can't they do that? Because federal law makes that illegal. That's discriminatory. You can't have adult only swim times. So it discriminates on the basis of age, which is a prohibited class, just like race. It would be like saying, only this religious group gets to swim on Mondays. Well, no one would ever do that, but age is the same protected class. So disagree with it, you're certainly welcome to. If you're motivated enough, you could talk to your federal legislators and see if they can change it. But it is a thing, and I don't see it going anywhere anytime soon. Another thing that's not going away, and that's records, questions, demands, litigation. And let me go ahead and start by saying a couple of things on records. The fact that a person thinks a record exists doesn't mean the association has that record. The fact that an association at one point had a record doesn't mean it's still in existence. Again, we're dealing with nonprofit, volunteer, non-compensated board members who on average move houses every 3 years. I mean, the record keeping for associations is not what you would expect from a small business. So it may not be anywhere near what you do as an individual. If you think that that's terrible for your association, the A+ position for you to be in is on the board and in the driver's seat of improving those records. So the fact that we think that the record should exist doesn't mean that it does. The fact that it existed in the past doesn't mean it continues to exist. Okay. So what are the records of the association, and how this question comes up too, how long should we keep them? So this is all my opinion. It's certainly subject to a different opinion, changes in the law, your governing documents. This is what I think. So minutes, resolutions, governing documents, architectural review committee files, enforcement litigation files, all of that should be kept indefinitely, not necessarily because we will need them, but so, for example, the ARC and the enforcement litigation files, those might be helpful to future ARC or boards who are enforcement. This certainly doesn't mean that these items have, as a matter of law, to remain indefinitely. 7 years, tax returns, any audits, which more than likely there aren't any, reconciled bank statements. We'll get into why reconciled bank statements are lovely things. Basically, the financial picture, history of the association, and then discretionary. Discretionary means to the extent the board wants to keep this, needs to keep this, feels that it's important, or has a means or mechanism to do it, then do it. Keep it indefinitely, keep it 7 years, destroy it immediately. Just, it's up to the board and what their needs and wants are. One of the things that makes record keeping really simple, particularly when it comes to complying with records requests, is scanning or digitizing, keeping these in electronic format. That's easier and easier these days. It also will minimize on board member, manager, attorney response time when people want to make a records request. And that way you don't necessarily have to get the physical books and records in a room together and have people go through them. You can just, okay, what is it that you're wanting to see? And you can just email it or put it in a folder and give people access to it. There's more questions on records. We can talk about that in part 2, but we'll be back on Thursday. Anna, thank you for bringing my attention to the comments and shepherding that. And with that, I will turn my mic off.
All right. Well, thank you, Matthew, for all your time and expertise shared this evening. Again, we will be meeting on Thursday from 6 to 8 p.m. It will be the same link that you used to join this evening from Neighborhood Alliance. We appreciate everything that you do for your neighborhood and spending this time this evening learning more about how to manage your HOA. So with that, we'll finish tonight. If you need more information, I'm going to put up the slide that has Matthew's contact information on his law firm. So you're welcome to stick around, write it down, but we'll be back on Thursday to cover more information and continue with the topics that we haven't covered today.
Thanks, Anna. Bye-bye.
Bye. Thank you, Matthew. Good evening.